Hello, citizens. Okay, imagine this. You're a government employee accused of a crime and you're locked up in jail.
You're sitting behind bars, completely helpless. And then your boss sends you a letter saying you are fired, with zero chance to defend yourself.
Wait, without a departmental inquiry? I thought they had to give you a hearing.
Usually, yes, but they bypassed it, claiming you're too dangerous and might intimidate witnesses.
But I'm locked inside a jail cell. How could I intimidate anyone from in there?
That is exactly the million-dollar question. And it happened in real life to a Delhi police constable named Manohar Lal.
Okay, so how did this constable end up fired from a jail cell?
In 2017, Manohar Lal was accused of being involved in a sandalwood robbery. He was arrested, and less than 3 weeks later, his deputy commissioner just straight up fired him without an inquiry.
Hold on, so they just cancelled due process? I thought government jobs had constitutional protection.
They do, but the police used a preliminary report to claim he had criminal ties. They argued that because he might threaten witnesses, holding an inquiry wasn't reasonably practicable.
From his jail cell? That sounds like a massive stretch.
It was, but when he appealed it, both the Central Administrative Tribunal and the Delhi High Court actually agreed with the police. Wait. The High Court said bypassing the inquiry was fine. Why? They figured that since he was given a hearing by an appellate authority much later, the original firing was somehow justified. But Manohar Lal refused to back down and took it to the Supreme Court. Let me guess, he brought up his constitutional rights? He brought out the heavy artillery, Article 311(2) of the Constitution, which guarantees a civil servant's right to a proper inquiry. So how did the police legally justify skipping it in the first place? They used a constitutional backdoor, Article 311(2) second proviso, Clause B. It basically says, if holding an inquiry is practically impossible, the authority can just skip it. So basically a license to fire anyone if the boss just says it's too hard.
And this is where the Supreme Court dropped the hammer. They pulled out the landmark Tulsiram Patel case and said you cannot use this exception as a lazy shortcut.
So the boss needs actual proof, not just a gut feeling.
Exactly. Relying on the Jaswant Singh case, they ruled it cannot be based on the ipse dixit, the mere whim or caprice of the boss. You need objective facts.
Oh, I love it when judges demand receipts. Did they actually look at the evidence?
They did something amazing. They read the original preliminary police report. It had statements from 4 witnesses, and not a single one of them said they had been threatened.
Wow. So the court realized he couldn't possibly be terrorizing people from inside the government's own jail.
Spot on. The court called out the blatant common sense flaw. The claim that witnesses might be intimidated was purely an imaginary presumption.
So what was the final verdict for Manohar Lal?
Total victory. The Supreme Court quashed the dismissal entirely and ordered his reinstatement with continuity of service and 50% back wages.
That is huge. So for every government worker listening, your constitutional job security is real. Your boss cannot fire you on a hunch or a guess.
And for the legal professionals listening, take note. The court made it strictly clear that an appellate hearing granted after the fact does not cure an initially illegal dismissal.
Because if the foundation of the firing is illegal, you can't just patch it up later.
Exactly. Courts will actively pierce the veil to demand objective evidence. Due process is a constitutional mandate, not a management suggestion.